SEBI, and NISM are officially on the hunt for India's sharpest minds in the National Financial Literacy Quiz 2026. Whether you are a UG or PG student, this is your arena. Phase 1 is the college round. Crush the college round and you move to the regional round. And finally, we'll fly to the grand finale at the NISM campus. The college round is live right now. Scan the code.
So this was about the National Financial Literacy Quiz, which is a joint initiative of NISM and SEBI. For more info, you can visit our website nflq.nism.ec.in. So hello and good evening everyone. I am Mansi Ghanikar, working in the Investor Education Department of NISM. NISM is the capacity building initiative of SEBI. We at NISM conduct a wide range of activities at various levels with the objective of improving quality standards in the securities markets. At NISM, we work in 5 broad areas: long and short-term academic programs, certifications for market intermediaries, e-learning programs, training programs for working professionals and academia, and various investor education initiatives. Today, we introduce a series on succession planning awareness comprising 5 episodes scheduled on every Wednesday of April 2026. The first episode is today and will be conducted by Dr. Deepak Jain, and the topic will be Introduction to Succession Planning. Mr. Deepak Jain is a highly accomplished and renowned financial expert with over 25 years of experience. He is the founder, director of American Academy of Financial Management India and the managing director of NextGen Estate Planning Solutions Private Limited. Mr. Jain is a master trainer and has trained over 45,000 individuals, including wealth managers and financial advisors across India. With his expertise in financial planning, wealth management, estate planning, portfolio management, asset protection, and business succession planning, Mr. Deepak is dedicated to improving the financial well-being of individuals. He is also an author, speaker, and coach known for his captivating and motivating presentations. Now, I would request Deepak sir to begin with the session.
Thank you, Mansi. Thanks a lot for this kind introduction. So let us start the session. Yeah. Just give me a minute.
Sir, you can share your screen.
Yeah. I am now able to do that.
Yes.
Okay. So, good evening to all of you. It's a pleasure to have all of you in this session, which is on Introduction to Succession Planning. And whenever I start this session on inheritance, succession, or estate planning, I ask a question. And I'll ask the same question to all of you. Question is very simple. Question is, if you die today, what would you leave behind for your family and children? An inheritance or a mess? All of us want to leave an inheritance for our children, for our family, but most people end up leaving a mess for their children and family to sort out. This session or this series of session is all about how to leave an inheritance, not a mess. Right? So by the end of these series of sessions, the 5 sessions we will be doing here, you will know actually what to do to leave an inheritance or not a mess. And let me tell you, this is a primer. What we'll be doing today is just the opening statement, right? When you go deeper into it, you'll know much more about these kind of things, which everybody should know. Now, let me begin by telling you what is wealth management. So when we talk about wealth management and we all want to manage our wealth very well, there are 3 basic motives of wealth management. Three basic reasons, three basic objectives which you want to achieve when you are doing your wealth management. First, you want to enhance your wealth. You want to accumulate the wealth. You want to grow the wealth. Second, you want to preserve this wealth, protect this wealth. And third, you want to distribute this wealth. Now, most people today pay most of their attention on wealth enhancement or accumulation of wealth. They ignore things like wealth protection planning and transfer planning. Today's session is all about wealth transfer planning. And wealth transfer planning is also called as estate planning. And whenever I start a session on estate planning for common investors, I have to make one point very clear. This is not about real estate planning. Because this term estate is common between real estate and estate planning, people generally people generally confuse between real estate planning and estate planning because the word estate is common. So let's first understand what makes up your estate. What actually is your estate? And the definition says everything which you own today is your estate. Everything which you will own on the date of your death is also your estate. And everything you own after your death is also part of your estate. But my question here to you is a little different. My question to you, all of you, is do you know what do you own today? If I give you a plain piece of paper and I ask you to write the name of all the assets you own today, how many of you can create a complete list? How many of you can create a complete list? Just type a one in the chat box if you are allowed to do that, if you know what you own. Right? If you actually know what you own today and you can create a complete list, I don't know whether chats is you. Sahil, do they have access to the chat?
So they have access to the Q&A section. They can type there.
You can type in the Q&A section. One, if you know what you own today, and two, if you don't know what you own today. Great. I want each one of you to answer this. Do you know what do you own today? Because 99% people in this world do not know what they own. So let me first prove to you that you do not know what you own. I'll give you an example. There was a businessman. He gave his business to his elder son through a will. Post his death, his elder son inherited this business because the will was successfully implemented. But because he did nothing, his younger son got hold of his mobile phone number and email ID. Now what will happen? Business goes to the elder one, and the younger one gets hold of mobile phone number and email ID. Two possible things can happen. Either both the brothers start fighting, or business gets transformed from the elder to the younger. But the question is, when I ask you to make your will, how many of you would write in that will, post my death, my mobile phone number goes to this person, my email ID goes to this person? Is your mobile phone number an asset or not? Is your mobile phone number an asset or not? So, so most people do not know what they own. In today's world, a normal person has four types of assets. And please make note of these. First are called physical assets: land, building, machinery, jewelry, gadgets, whatever you call them. Second are called financial assets: shares, mutual fund, bank account balance, small saving schemes, provident fund, PPF accounts, etc. etc. Third, which are becoming very, very important today, they are called digital assets. Digital assets. Digital assets. Mobile phone number, email ID, website URL, domain hosting, YouTube channel, Facebook page, Twitter handle, and there are some exotic ones also which you won't list down. Credit card points, miles on an airline, and lastly, there are intangible assets, assets which I can't touch. Your trademark, your logo, your relationships, your knowledge, your goodwill, your IPR, your patents, your copyrights. Are these not assets? And there are certain assets which even I could not classify, right? And this I know most of you would not even have thought of. I'll give you an example of such an asset. It is called tissue on ice. Have you heard this term, tissue on ice? I'll give you an example of tissue on ice. When a child was born, you froze their stem cells for 99 years. Is that not an asset? Is that not an asset? It can save life of a generation. So most people don't know what they own. The definition further says everything which I will own after my death is also my estate. What are possible things which you might own after your death, apart from an insurance policy claim which you already know? Let me give you an example of things which you might own after your death. Suppose you are traveling in that Malaysian aircraft that crashed, and government of Malaysia pays a compensation of 5 crore rupees post your death. Who owns this 5 crore rupees? And if you say my legal heirs, my family, my spouse, you are completely wrong. Because the real owner of this money is the person who died, the deceased. And this person could have given away this wealth, this compensation money while he was alive. And you can ask me, how can I ever give away money which I never ever know I will ever own? If you get your will made by a good lawyer, they always add a clause to the will, which is called the residual clause or the remainder clause, which basically says if I ever own anything which is not mentioned in this will, it will go to these people in these proportion. And sometimes this residue becomes bigger than the main. So please make your residuary beneficiary very knowingly in your will. So you understand what is your estate? Everything which you own today is your estate. Everything which you own on the date of your death is your estate. And everything which you own after your death is also part of your estate. Then what is estate planning? What is estate planning? Estate planning is a systematic plan to distribute one's estate according to one's wishes in future. When you systematically plan how your estate would be distributed post your death, that planning is called estate planning. That planning is called estate planning. And what is the ultimate objective of estate planning? To fulfill the estate owner's wishes as closely as possible. I, as a estate planner, work for only one person, the person who owns this estate. And my job is to ensure that this person's wishes and desires are taken care of, whether this person is alive or dead. Now, I will ask you some questions, which I want all of you to answer in the Q&A section. Each of my question has only two possible answers, a yes or a no. If your answer is yes, you will type a 1 in the Q&A section. If your answer is no, you will type a 2 in the section. And you have to answer it for yourself. Right? If your answer is yes, I want this to happen. Yes, it will be good if this happens. Yes, I will ensure this happens. Then type a 1 in the chat box. Otherwise, type a 2 in the chat box. Right? My first question is, do you want to have full control over your property while you are alive? Do you want that your property remains under your control till you are alive? How many of you want to retain control over your property while you are alive? Just type a 1 in the chat box. Because all of us should ensure that we retain control over our property while we are alive. Why? Because this control of yours over your property ensures your financial security. And people who give up this control while they are alive, they repent over it for the rest of their life, because this control living leads to financial disaster. You are secured because you control your property. There is one message which I repeatedly pass to my participants, that is, love everybody in this world. Love them as much as you can, but please don't love a person more than yourself. There is virtue in selfishness. Only a secured person can help anybody else. You need to be secured first to help other people. Don't, there is virtue in selfishness, right? My second question is, in case you become disabled or incapacitated, would you still like to take care of yourself and your family members? Suppose you are in coma, you are paralytic, become mentally unsound, you have Parkinson, you have dementia, you have Alzheimer. Under such conditions, also, would you like to take care of yourself and your family members, at least financially, if not physically? All of you would like to do that, please type a one in the chat box, in the question answer session. Right? I know all of you would like to do that. Now comes my third and the most important question in this series of questions. That is, do you want to give what you want, to whom you want, the way you want, and when you want on your death? Do you want that post your death, your property only goes to people you want it to go, at the time you want it to go, in the manner and mode you want it to go, and in the amount and proportion you want it to go? That means you not only want to keep control over your property while you are alive, we also want to maintain that control even after we are dead. And my last question in this series of questions is, do you want to ensure a easy, peaceful transfer of your wealth to the next generation? Do you want that your wealth post your death easily and peacefully goes to your next generation without any fighting between the inheritors, without them having to go to court, meet lawyers, visit financial institutions? How many of you would like to ensure a easy, peaceful transfer of your wealth to the next generation? Just type a one in the chat box. Now, how many of you have answered these four questions as yes? Because if you have answered these four questions as yes, then you need to do estate planning, you need to learn estate planning. If you ask me why should I do my estate planning, I will say because you want to retain control over your property while you're alive. You want to take financial care of people and yourself in case you become disabled. You want to ensure a easy, peaceful transfer of your wealth to the next generation. And you want that your property is distributed as per your wishes and desires. That's the reason you should do your estate planning. And I know each one of us needs our estate planning, because all of us want to ensure that these four questions answer is yes for us and our next generation. So, Sahil, can you launch the first question? The
Yes, sir.
first poll? Yeah.
Done, sir.
Right. So we have given you four options in this poll. Right. What what worries you most out of these four? Family disputes after death, minor children not being protected, assets not going to the right person, family not knowing what I own or where it is.
So we'll wait for 60 seconds and then I will share
Yeah.
the results.
Yeah. Yeah.
Yes, so I'm sharing the results. Yes.
So loss of information is one, and family dispute is the second. Assets not going to the right person is the third, and minor children is the fourth choice. Great, great. So let's continue. Let's continue. Now, why you should have a estate plan? What is the reason of creating a estate plan? You should have a estate plan because you want to clearly give your property as per your wishes. You want that it goes as per my wishes and desires. Question is, suppose you die without telling your wishes or desires, would it still be distributed or not distributed? It will still be distributed. But now it will not be distributed as per your wishes and desires. It is distributed as per law. And in India, this law depends on the religion you follow. And these laws are called succession laws. And these succession laws generally cause complications because the law is same for all people. If I am a Hindu and Hindu Succession Act 1956 is applicable for me, and I am a Hindu male, irrespective of my family situation, irrespective of my desires, a Hindu male's property would be distributed in the same way for all Hindu males. So law doesn't know your requirements, your family situation. It is same and it causes complications. And last reason is to minimize disputes in the family after death, so that chances of dispute after your death are reduced. You should create an estate plan. Question is, what is the real motive of doing estate planning? Why should I do my estate planning? Should I do my estate planning because I want to divide my wealth? Should I do it because I want to distribute my wealth? Should I do it because I want to pass on your wealth? Should I do it because of wealth? Is the purpose my wealth? Please remember, estate planning is not at all about wealth. This is not about wealth. ये wealth का मामला ही नहीं है. This is not about wealth at all. The real reason of doing estate planning is not your wealth. Because the real reason of doing estate planning is and always will be people you love the most, whom you will be leaving behind one day. The real reason of estate planning could be your spouse, could be your children, could be your parents. These are the real reasons. Your wealth is for whom? Ultimately, for them. So, who's more important? Your wealth or them? Obviously, them. Obviously, them. Never ever think I should do my estate planning because of the wealth I have created. I should do it because of the people I am leaving behind. Those are the real reasons of doing estate planning, right? Now I'll give you some concerns. As first, I'll start with the family concerns, and you tell me whether it's a concern or not. First concern is risk that your assets after your death might not fully pass on to your spouse, because if you die without a will, other people apart from your spouse are your legal heirs. Question is, if you die without a will, people think because I am married, everything will go to my spouse, which is not the truth. Which is not the truth. Because as per law, your legal heirs are very different. I'll give you an example. Suppose you are a Hindu male and you die without a will, right? And you die without a will. Then who are your legal heirs? For a Hindu male, I'm just telling you your legal heirs, you can note down. On the top, write the name of your mother if she is alive. If you are lucky enough to have a mother who is alive today, write her name on the top. Below it, write the name of your wife if she is alive. Below it, write the name of all your children who are alive today. Doesn't matter son or daughter, minor or major, adopted or biological, married or unmarried. If you have a child and that child is alive and you are a Hindu male, write the name of the child who is alive today. And below it, if any of your child has passed away, leaving behind a child or spouse who's alive today, write the name of the child who has passed away. Now count the total number of people you have written. Your wealth would be equally distributed between these people. That's the Hindu succession law 1956 for a Hindu male. Is this system of division acceptable to you? Or do you want that first it goes to my spouse, then to my children? And if you want that first it goes to my spouse, then to my children, please create a will. In absence of will, this is how it will be distributed. Right? Right? So, when should a person make a will? By what age should a normal Indian create a will? What is that ideal age to create a will? Right? What is that ideal age to create a will? So, so if you want to know the ideal age to create a will, I do a small exercise with the participants. And the exercise is very simple. On a piece of paper, write down your date of birth. I will tell you the ideal age. On a piece of paper, write down your date of birth in DD, MM, YYY format. First the date, then the month, then the year. Just write it down. You want to know the correct age to create a will. The correct age for you to create a will. Now below it, write down your date of death. Hmm? So when should you create a will? Before you die. And none of us know our date of death. So what's the best day to create a will? Today. But you are late. The best day to create a will was the day you turned major and acquired your first asset. That was the best age, best day to create a will. That day you missed, but you are lucky that you can still create it. Many people in this world have gone without creating a will or become incapacitated without making a will. And who has suffered because of it? People they loved the most. People they loved the most have suffered because of their inaction. Don't leave that sadness after you. Don't leave that sadness after you, right? Create a will today. Don't ride on your luck. The next question I need to ask you is, in case you and your spouse pass away while your children is a minor, someone other than your choice might become their guardian. So how many of you have minor children? Children less than 18 years of age? If you have a minor child, in case both you and your spouse pass away while the child is minor, I am talking about who gets the custody of the child. I am not talking about money of the child. And many parents think that the custody would go to the grandparents or the maternal grandparents, which is wrong. Because as per the Indian Guardianship and Maintenance Act, there are only three types of guardian. First is called natural guardian, and only parents can be natural guardian to a child. In absence of parents, society becomes the guardian of the child, and society is represented by the district judge. Now, it is the district judge prerogative to appoint or give custody of the child to a person whom they think would act in the best interest of the child. And such a guardian appointed by the judge is called the certified guardian or the legal guardian. But judges in India prefer giving custody of these children to, to organizations rather than individuals. And what do you call those organizations who take care of children whose parents are not alive? You call them orphanages. Would you like your child to go to an orphanage in case both of you pass away without the creating without appointing a guardian of your child. If you don't want that, the law has a provision of a third type of guardian that is called testamentary guardian. Each parent is allowed by the law to appoint a guardian of their children while they are alive. Such a guardian is called testamentary guardian. And the document to create this guardian, testamentary guardian, is called letter of guardianship. If you have created a letter of guardianship, the custody of your child will go to people mentioned in this document, not to the choice of any other person apart from you. Please create a letter of guardianship. Your most precious asset wealth in life are your children. And if they are minor, you have left them unprotected today. Very, very important document to create a letter of guardianship. I go further. Risk of loss of information. Uh, Before I go this, Sahil, you can launch the next poll.
Sure, sir.
We are asking you, if something happens to you, who would know your assets and document well enough to take action? Choices are: my family knows clearly, only my spouse know, somebody in the family knows partly, and nobody really knows.
Yes, so I am sharing the results.
So B, C, and D are my concerns. Because only if your spouse knows, then suppose there is a simultaneous death scenario, then nobody knows. Somebody in the family knows partly and nobody really knows are real concerns, right? So this is a question. Risk of loss of information that dies with you, such as details of your assets, debtors, creditors, information about passwords to your email ID, etc. What have you done for that? What have you done for that? And what can you do for that? For this, you can create a document which is called an asset information sheet or a death dossier, which ensures that the information after you does not die and it goes to people, correct people after you. It's very important that you keep on updating this information and make sure people apart from your spouse get access to this information in case both of you pass away simultaneously. Now I'll come to some disability concerns. In case you become incapacitated, suppose you are in coma, you are paralytic, you are mentally unsound. Under such situation, who would be able to operate your singly operated bank accounts? Who would be able to redeem your mutual fund holdings, fixed deposits? If you have rented out a property, who would be able to take that rent on behalf of you and renew the rent agreement? What have you done for that? And what can you do for that? For that, we create a special type of power of attorney for incapacitation, which is called the springing durable financial power of attorney for incapacitation. It's a specialized document which allows somebody to step into your shoes only in case you are incapacitated and do things which you allow them into in this power of attorney. The document name is Springing Durable Financial Power of Attorney for Incapacitation. Very, very important document to create. Now I go to my next concern. And for this also, I'm giving you a situation. I am sorry I give these kind of situation. My job is such. Situation is, suppose you are on a ventilator for more than 10 days. Less than 5% chance of reviving. But doctors keep you artificially alive. Why? Because they are legally obliged to do it. That's a legal obligation on the doctors to keep you alive as long as they can. And maybe some of them think that we are making money on his body. Very rarely. Generally, doctors do it because of the legal obligation. But the question is, how does it affect you? It affects you in two ways. First, you are in lot of pain. Have you seen a terminally ill patient? Where all do they put the tubes? Even looking at that person makes you feel the pain. And second is, your wealth would slowly go to a doctor, nursing home, or a hospital. Can you do something about it? In 2019, Supreme Court in a landmark judgment said, right to die with dignity is the fundamental right of every Indian. And you can enforce this right of yours by creating a document which is called Living Will or Advanced Healthcare Directive, where you mention conditions under which life support should be withdrawn from you. So you can create this document. We suppose with this condition, if I'm on a ventilator for more than 10 days, brain dead, less than 5% chance of recovering, switch off the ventilator and keep giving me painkillers. That's a legally enforceable right in India today. You can refuse to rot on a bed, provided you create this document called Living Will. And let me also tell you, Maharashtra is the only state in India which has appointed custodians for this Living Will. You can go to any municipal corporation across Maharashtra and you can find a custodian where after creating this living will, you can give it to the custody of the custodian where it becomes more legally powerful. Other places, even a notarized version works. Here you have to appoint an attorney, person who would inform the doctor and take decision or ask the doctor to enforce the living will. So, four estate planning documents which are required by everyone, which we discussed today: a will, a letter of guardianship, a financial durable power of attorney, a living will, and one more document that is called asset information sheet. Out of these four, how many have you created till date? And will you leave an inheritance or a mess for your children to sort out if you die today? And I will end my talk by asking you a very, very pertinent question. And the question is, would you like to leave your wealth or give your wealth on your death? आप अपनी संपत्ति छोड़ के जाना चाहते हो या दे के जाना चाहते हो इस दुनिया से? If you want to give your wealth, create an estate plan today. Because if you leave it, you leave disputes, you leave non-clarity, you leave spoiled relationships. But when you give an inheritance, you give them security, you give them care, you give them love, which are more important than anything else in this world. So that was all from my side, right? And we are open for question and answers. We are open with question and answers.
So I think we can run our remaining polls.
Yeah, please, please.
Yes. So until the attendees answer the poll, I think you can touch upon the key takeaways or the session highlights or the important points that attendees should remember or by your
So,
knowledge.
first of all, please agree that this is not an optional thing to do. It's a compulsory thing to do, right? So I cannot delay my inheritance or estate planning any further because I am already too late. Second, the default choices in the law might not work for everybody, right? So if you want to leave it as per your wishes and desires, do it. Third, inheritance planning is not only about what happens after you die. It also takes care of incapacitation, what happens while you are alive. Fourth, there are three layers or three things which you have to think when you are doing inheritance planning. First is access, second is control, and third is distribution. How do I ensure access to my wealth? Who will control it and who will get it? These three people can be different, right? These three people can be different, and you need to create a structure for yourself, right? Because the time is permitting me, uh, let me tell you one thing. I've been into this field for last 13 years, and within this 13 years, what I've learned is estate planning is 90% emotions and 10% legality. The most difficult things in estate planning is the emotional side of it. I'll make some emotional statements and then I'll counter them. If I ask most of you, how would you like to divide your wealth amongst your children? All of you would say one thing. Most of you would say one thing, and that is equally. We will be fair to all. We will give it equally to all. My question is equal fair? Most cases, equal is not fair. I can give you hundred of examples where equal is not fair. Suppose you have two children. Do they have the same family obligations? Do they have the same kind of children? Do they have the same life goals? Do they have the same money management skills? Do they have the do they have they cared about you the same? Or do they care about you the same? Have you spent the same on all of them? Not possible. Then how can you give wealth equally? I go to the counter argument to this. One of your child is doing very well in life. Other one is struggling financially. What would you do? You will give more to the child who is struggling in life and less to the child who is doing well in life. But by doing so, you are punishing success and rewarding failure. Hmm? The child who listened to you always, was disciplined, did everything well, he's being punished for being correct, and you are rewarding somebody who hardly did anything. Are you fair? Problem for the parents is you have to be fair and appear to be fair. And that's the most difficult thing to do in the world. So when you talk about estate planning or inheritance planning, please think about these emotional aspects of estate planning also. Legalities I can teach you in a session. What is allowed, what is not allowed, what's not. But if you don't master or think about these emotional aspects of estate planning, you would not be doing justice to your estate in inheritance planning. I'll end this talk by asking you a question. Do you transfer your valuables in your will, or do you also transfer your values in your will? Just does inheritance planning only transfer the valuables you have acquired in your life, or does it pass the values which are so important for you to the next generation? It transfers both, sir. And because of that values of your family, these valuables were created, and it should not violate the values of your family. Your family's values were work hard, and you're giving wealth to person who's hardly worked. What does it reflect about you? What kind of person are you? So please look at the emotional aspects of it before creating an inheritance plan. And the last message is just do it. Don't keep on postponing it like you have been doing till now. Okay. So, Sahil, we can launch the next one also, the last one.
Sure, sir. Yes, doing. Done. Until then, I think attendees can ask their question in Q&A so that sir can address those questions. So there are few questions I think you can pick up which you
Okay.
feel are relevant to the topic.
So, there's a question by Mr. Sanjay. For a brain dead patient, who decides how his body parts can be donated and who it can be donated? So, sir, the living will is not the instrument to give organ donation. For that, the government of India has a separate website where this person can register and say, I want to donate my these organs. The reference of that website code which is generated can be given in the living will, but there is no specific performance rule in India. Your children may or may not donate your organs. Then Alok Bansal has asked, what should one do about jewelry? So, Alok ji, my biggest worry is I have read hundreds of will. There are certain mistakes people do when they have real assets and they mention percentages or ratios. They leave behind a dispute. Suppose I have land. I said 50% to the elder son, 50% to the younger son. But I have not mentioned which 50%. Both the brothers want one which is near to the road. No one wants the backside. Similarly, I have jewelry. I said one third to my elder son, one third to my younger son, and one third to my daughter also. Problem is, both the brothers and the sister want the same necklace. So what have you left? Dispute. If you have physical assets, they need to be specifically divided. If you have land, include the land map as part of the will and create a clear demarcation in the map and say this part belongs to this person, this part belongs to this person. If you have jewelry, click photograph of each piece of jewelry, give it a number, and then in your will write 1 to 10 goes to this person, 11 to 20 goes to this person, 21 to 30 goes to this person. Please remember, more clarity you leave, lesser is the chance of dispute. One more thing, for jewelry, I have another solution which is even better. Suppose you have two children. So you open two separate bank lockers, and in your will mention contents of locker A goes to son A and content of locker B goes to son B. Why is it better than the first option I gave? Because it has flexibility. Tomorrow, if you want to change, you just have to put goods, jewelry from one locker and shift it to the other locker. Your children also know he can change or she can change. Or you are also very sure I need not change my will. I can just change the contents of the locker. Right? So for that locker, that's my suggestion. Either of the two suggestions you can do. So what is the procedure for submitting a living will to the designated custodian? So you need to identify the custodian, but before going to the custodian, this will has to be notarized. Create 3 copies of this will. One copy is submitted to the custodian, and other two are retained by you, one for yourself and one for the attorney you have created in the will. Right? The custodian would give you a receipt of the custody of the document. Right? There was a question: can we do a will that is not complete as of now due to various reasons? No, will has to be complete, and anything which you are not very sure, you still have to decide. I can't leave incomplete things in a will, because that's a incomplete document can create problems today. But if your clarity is, I might get more assets in future, right? Uh, so how do I include them in my current will? So you create the residual clause. But if you're not sure what to give to which person, then it's a concern, right? So if that clarity is missing, I can't create a good will for you. No. So one single will not have these 4 documents. These are 4 separate documents to be created, right? So these are 4 separate documents to be created. One single document cannot have this. Okay. Omkar Shrikant has asked a question: who is the perfect witness for a will? So how to choose a witness for a will? So first of all, this person should be a well-wisher of the family and yourself. That's the first thing I will first see: is this person a well-wisher or not? Second is, this person should be younger and healthier than you, who is more likely to outsurvive you. Third, this person should be a person of integrity and capability of acting as a witness. Tomorrow, if the court wants them to want this person to dispose in front of them, this person is ready and willing to go to the court. Right? Should it be a doctor? Not necessary. Not necessary. Right? What should you avoid at all cost? Never make a beneficiary or the spouse of a beneficiary as a witness. That's not allowed in the Indian Evidence Act. So if you have hidden assets which you don't want to reveal, you include them in your residuary clause. Or these assets, if they are physical assets, they can be made part of a bank locker, and that locker contents are given to a person without naming the content. So he's asked another question we offer here: nominee is just a trustee. In what specific scenarios does a nomination actually overpower a will, and where does it fail? So for all financial and other assets, nominee is just a trustee or a distributor of the funds. But there are 2 exceptions to this. First is life insurance policy. In 2017 September, Insurance Amendment Act was passed by the Parliament, which modified Section 39 of the Insurance Act, which dealt with nomination. And they introduced a first time nominee in the system, which is called beneficial nominee. And they said if the nominee in a life insurance policy is either of the parent, spouse, or child of the life assured, such a nominee would be called as beneficial nominee. And beneficial nominee would get the claim money to the exclusion of other legal heirs. So in a life insurance policy, the nominee becomes the owner. And most probably it would overpower the will also. The second is the Public Provident Fund. In the PPF Act, it is written the nominee is the owner. But PPF nominee can be overcome with a will. But if there is no will, it goes to the nominee, other cannot claim it. Right? All other places in India, whether these are mutual fund accounts, whether these are uh, bank accounts, etc., etc., society flat nomination, nominee is just the trustee or the person who is in charge of dealing with the institution, not keeping the money. So Harshdeep Singh, people in India are not ready to discuss after their death planning. People are not very ready to discuss about inheritance planning because one, death is not a uh, very happy situation to discuss, right? People are fearful about discussing their death, right? And second, many people think we are, by discussing these things, we might be preponing the conflict in the family. Some people don't reveal this because they think that if I tell my children how much wealth I have, maybe they'll stop working. These are the real reasons why most Indians are reluctant, or most people in the world are reluctant talking about wealth. It's not about India. Question is, how can you motivate people to do it? You tell them the consequence of not doing this plan. Because each one of us want to leave an inheritance for our children, not a mess. That should be the reason why they should do it, right? So there is another question from Omkar ji who says, in which Indian state cities probate is mandatory today? So after this recent parliament change of law, probate is not compulsory in any city or state in India. Previously, Mumbai, Chennai, and Calcutta, being a residential towns at the time of Britishers, it was mandatory to get the will probated. Now that law has been scrapped by the parliament. So now probate is not mandatory in any part of India, but it is highly desirable because the title one receives from a probated will is more secure, more sound than if you receive a title without a probate of the will. Also, you have asked, can I will my share of an HUF property? Yes, sir, you can will your share of the HUF property to anybody you require. Ancestral is self-acquired, will take too much time to explain. But I can tell you one thing, any property which has been divided once in meets and bounds does not remain as an ancestral property, it becomes a self-acquired property. So my great grandfather had a property which came to my grandfather and his three brothers. It remained undivided. It is still ancestral. But when it came to my father's generation, each one divided the property. My father knew exactly which one-sixth property is his. Moment that division occurs, the property loses its characteristic as ancestral property. It becomes a self-acquired property. There's a question with Rajesh who says, is a handwritten, unregistered, non-notarized will considered legal? A will need not be registered. It need not be on a stamp paper, right? And it need not be typed. So I can create a will on a plain paper in my own handwriting, and there is no necessity to get it registered. The only necessity is I should sign in front of two witnesses who countersign and say, I saw him signing. The will is valid. But should you do all three of them? Should you get it registered? Should you put it on a stamp paper? Should you register it? Should you get it properly typed and drafted? I will say yes, because that makes the will more sound and more difficult to challenge. Uh, there's another question. Can I make a will showing the property I'm supposed to get from inheritance? You can you can include your future properties in your current will. That's allowed. That's allowed by the law, right? That's allowed by the law. I think we are coming to the end of the session. So any more questions? We will be having more such sessions and we'll go in deeper into it. Our next session next week, same time, is on succession laws, where we will be discussing the various succession laws as per the religious, because India it is religion based laws. So we'll be discussing how a Hindu property is divided, how a Muslim's property is divided in case they die without a Villain, what should you do to prevent those situations if you don't want that to happen? So uh, I think this is the time we had. So Sahil, over to you.
Yes, sir. I think you have answered most of the question which were asked. I can see there are 243 means 240 plus means type students as attendees has typed their queries and answers. So yes, on that note, I would like to extend our heartfelt thanks for your time and the knowledge which you have shared with us all. Also, thank you to all the attendees who have joined today's webinar. Also, before leaving, I will request all the attendees to take part in this feedback question as I have launched. So this feedback question will help us understand the content which you are looking for and to deliver the best. So do participate in this feedback poll question. It's a set of 5 questions, I think. Yes, it's a set of 5 questions. So do participate in that. We'll wait for 1 to 2 minutes so you all can answer the questions. Yes, so I think we can conclude the session as I can see 75% plus attendees has took part in the question. Yes. So also ensure that to join the second episode for this series, which is scheduled for the 8th April, which is next Wednesday, and the timing will be same 4 p.m. to 5 p.m. Yes. Thank you. Thank you again, Deepak sir, for sharing your time.
Thanks a lot.
Thank you.
Thank you. Thank you. Thanks
Thank
a
you
lot.
so much, sir. Thank you to
Thank you.
all who joined today. Thank you. Now I will request IT team to close the session.